I'm sorry?
So I'm Thomas Styron, the living man, not Thomas Ulrich Styron, the entity you know me as, or as I'm in my papers. I'm here to address the matter.
All right, thank you. You wish to be represented by an attorney, sir?
No, I'm here, sir, Juris Incorporated Persona.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand.
Check back there. I'll take the cuffs off.
I don't know that we're going to be doing all that, but let me ask you something. On the Styron matter, I sent my bailiff back to get him to bring him back out. The court is of the understanding that defendant number one is being, I will say, uncooperative, has purposely done some things to make it difficult to bring him out. What I'm going to do at this point in time, we're not going to wait and not going to play his game. We will hear him next week because of his behavior today before the court. At this point, I will revoke his bond and I will adjourn the probable cause. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Tariq Day.
I am Tariq Samar Tariq Day, the executor of the Tariq Samar Tariq Day Living Trust and the registered owner of the Tariq Samar Tariq Day Ex Relatione Kingdomon Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the third degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role.
How
religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an indigenous person.
No, sir, what you're about to state is incorrect.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it or tribal rules.
is there
You
a
are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation so that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this
Yes, sir.
because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
Not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this what?
The defendant.
I see on the complaint is 14.
Is that your address, sir?
Excuse me. Yeah, that's correct. Excuse me.
All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry. Can I get that date again, please, sir? I can put it in my calendar.
July 25th. You were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I did. I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it. I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you stated at the last hearing.
Well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. Young man, you're going to figure out something. We're playing by my rules, not yours. So you do not say anything because you're going to figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending you for a competency, I can't hear that. I can't hear it motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay. No problem.
I've been on this bench almost 25 years and never have I ever been insulted in the fashion you just insulted this court. No. My turn. The very first case, when you say the first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located, this court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for 2 reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. Happy. All right. Court does call the case, People of the State of Michigan versus James Whitley.
People.
Your Honor, for the record, my name is Deputy Lieutenant Attorney Blake Lally, Mr. Whitley, standing to the right. Sir, please state your name.
James Thomas Whitley.
This is a continuation of the hearing. Is there anything additional from the people?
Nothing additional from the people here.
Anything additional from the defense?
Nothing, yes, Your Honor. One thing additional is that if the court finds that money bail is necessary, I believe that based on this case, an appropriate bail would be something like a $10,000. The current bond conditions regarding specifically a GPS tether with the exclusion zone and the drug and alcohol testing, I think, address what the primary concerns are in the report. He was intoxicated, and of course, he should not be around here. But the reason I think primarily that the $150,000 insurance bond is excessive is he has no history of any violence whatsoever. In fact,
Well, can I just stop you there? Because I have some concerns about the representations of what happened that were made to the magistrate at the time, and some of them made to me yesterday. I went back and listened to the arraignment, and my understanding is that the alleged victim in this case contacted the defendant to pick her up from Chelsea bowling lanes or something along those lines.
he went to Chelsea Lanes to make sure she got home safe, because she was intoxicated.
Right. And then after that is when this ensued. I'm having difficulty, well, let's put it this way. According to what I have, he shouldn't have been driving. That's number
Well,
one.
he wasn't tested. The allegation is that he was intoxicated. I don't believe he agrees with that characterization.
Mr. Bennett, do you know what you said at that hearing regarding intoxication? Well, first of all, I don't think there are two issues there. One, he wasn't supposed, my understanding is his license is revoked with restrictions, and that his activities in going there that night would not have been within his restrictions on his license.
Okay.
Right? Secondly, with regard to the incident, the indication is he was trying to get his keys which to then drive again, which would have been outside of his restrictions on his license. And there was at least the indication when there was a talk of intoxication that the defendant at that time may have been intoxicated.
I believe I said exactly that. He may have been intoxicated. Can I address that concern or not?
Go ahead.
Your Honor, if that's the concern is that he was driving when this happened, then, an added condition of he can't be driving without a valid license.
No. My problem is with the whole story. Because why is he getting his keys to drive when he's not supposed to be driving? Is what I'm having difficulty even understanding the events as you're telling me they may have existed at that time.
The story gets messy here. Conflicting accounts, possible intoxication, and injury. Who do you believe, the alleged victim or the defendant? This is where justice and chaos collide.
She was intoxicated at Chelsea Lanes. He wanted to try to drive her home. She refused. She drove her cell phone. I think I haven't seen the alcohol test. I don't know whether that's or not. He followed her home to make sure she got there okay. The parties, he had generally, I believe, according to the report, spent most nights there. Then they got into an argument and he tried to leave, couldn't find his keys, and that's when the incident with the bed, the phone, and the glass break came. I think, in my opinion, those sort of discrepancies are only, I guess, the absolute truth, I guess, would be relevant to bond, but the alleged victim has known Mr. Whitley for 20 years and said he's not violent, that this has never happened. So, regardless of whether or not there's a conviction for purposes of bond, he does not pose.
If I consider him a danger, yes. I mean, what I've got here is I've got somebody that shouldn't be driving, who may have been intoxicated, who would have driven on 2 occasions when he's not supposed to be driving in violation of his restricted license breaking law. Then I have this confusion about the incident. I don't even know why she would have his keys if it now is you're relating to me that he drove and then followed her, which was not the indication that I got from listening to the arraignment. And then an altercation occurs that results in what I would consider significant injuries to the alleged victim in this case, to the point of a level of medical care that was required regarding that person, which I think would have been significant. And then from that, does she have to keep moving?
Excuse me.
And then, it creates in this court's mind a level of potential danger that this individual poses, potentially to the victim as well as to the community. It certainly raises that level. because he's not this law-abiding person that you say he is, because he's obviously driving. I mean, he's got those previous convictions, which led to the revocation of his license, which led to the restriction, and he's violating that twice that night. So, I don't know. Understood. And what I am additionally indicating is that in listening to what was the representations at the arraignment regarding what transpired, listening to what transpired that day, hearing what is today, it's unclear to me that that's what actually happened. Because that's not what's been said on the defense side about how this whole thing comes about. I then end up with an individual that is severely injured where they're at the hospital getting the treatment that they're getting. There's some indication that that's her fault. Maybe. But then, and that the defendant is trying to get away. I just find that version of events, it may indeed be true, but I find it, at least at this point, to be sort of remarkable that that would be it. The court, go ahead. What were you going to say?
I was just going to say, I think it's my testimony.
Oh, I'm sure it certainly will, but I don't have that at this. Normally, when during a bond hearing, I have to assess it based upon what I see, and I would say also, with all due respect to the magistrate of this court, that making a statement of giving a PR, but then indicating that the people might file an emergency bond motion. How she'd know that, I do not know. But that, from my perspective, leads the court to believe that it was in part of the court's finding, but also as a result of what the court is looking at in this case, would find that her decision to issue a PR bond was indeed an abuse of discretion in issuing that bond. The court will leave all of the conditions that she set in place. I will set the defendant's bond in the amount of $35,000 cash share. Defendant remanded.
Thank you, Your Honor.
Bill 1. All right. Court's in recess. Thank you.
In this courtroom moment, a defendant makes an unexpected decision. He will represent himself without a lawyer. Almost immediately, the situation begins to spiral. Instead of addressing the charges, the man claims that he is not bound by the law. He argues that his religion and international declarations make the court's rules irrelevant. The judge listens calmly but quickly shuts down these claims. Religion and international statements, the judge explains, do not override the court's authority. Every person in the courtroom, regardless of their beliefs, must follow the same legal procedures. Despite the warnings, the defendant continues to resist. He repeatedly says he does not understand the court's rules or the authority under which the judge operates. At this point, the judge becomes concerned about the defendant's ability to participate in the trial. If a person cannot understand the legal process, the court has a responsibility to ensure they are mentally capable of standing trial. After considering the repeated objections and confusion, the judge takes a decisive action. He orders a formal mental competency evaluation. This ruling determines whether the defendant can legally represent himself or proceed to trial. What started as a routine hearing has turned into a dramatic example of courtroom authority, defiance, and the limits of self-representation. It's a moment that highlights how quickly control can shift in a courtroom when someone challenges the system.